shortcut. We're on the record in two cases. First case is cause number 317994. Second case is cause number 328693-1. Both cases are styled the state of Texas versus Cody Wayne Carroll. Mr. Carroll, would you please raise your right hand? Mr. Carroll, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
And your full name is Cody Wayne McCarroll, is that correct?
Yes, sir.
How are you doing, Mr. McCarroll?
I'm doing fine.
That's good. Mr. McCarroll, I have present in the courtroom, Miss Attorney Don Dusler. Attorney Dusler was appointed to represent you in cause number 317994. And you have another case, cause number 328693-1. It on the docket sheet, it shows that Attorney Don Dusler was representing you in that case, but through our research, Mr. Don Dusler was not appointed to represent you on that case, so he's not your attorney on that case. Now, Mr. Don Dusler has filed a motion to withdraw in cause number 317994. And Mr. McCarroll, have you received a copy? I have what is called an amended motion to withdraw as attorney. Mr. McCarroll, have you been served a copy of the amended motion to withdraw?
No, sir, I haven't.
Mr. Dusler, you did not serve Mr. McCarroll?
I don't know if I did or not, Judge.
Oh, yeah, he doesn't have any.
I can orally present the motion this morning.
Okay, well, let me do this here. Now, Mr. McCarroll, do you desire to be served with a copy of the motion, or would it be sufficient for you if Mr. Dusler read the amended motion to withdraw as attorney?
Why is he withdrawing and I mean, why? Yeah, I'd rather just get this taken care of today.
Okay, so let me do this here, Mr. Dusler.
Yes, sir.
Mr. Dusler is going to read you the motion to withdraw, and then you can just tell the court whether you is in agreement with it or against it. But just hold on a minute. Mr. Dusler, the microphone is right here.
Okay.
And so, okay, Mr. Dusler, you may proceed.
All right, sir. This is amended motion to withdraw that I have filed. Number one, I've stated that I've been appointed to represent the defendant in this cause. Number two, I have extensive criminal defense obligations in the Criminal District Court of Jefferson County, Texas, which do not allow me sufficient time to properly represent the defendant in this court. Number three, excuse me, pursuant to the rules of the Texas Indigent Defense Committee and the amended public defendant contract per the Criminal District Courts of Jefferson County, Texas, the maximum caseload allowed by me cannot exceed 150 cases per year. The cases handled by me in the Criminal District Court will come close to or exceeding the caseload workload limitation allowed by law. Per contract with Jefferson County, I must make all appearances in the Criminal District Court a priority over all other cases. As a result, my caseload will either be close to or exceed the maximum number of cases I'm allowed to handle, and furthermore, all felony cases will be given priority. This means that the misdemeanor cases handled by me will be given a much lower priority than all of the felony cases and make it virtually impossible to afford this defendant his right to a fair and speedy trial in this case. I made this motion to withdraw not for the purposes of delay, but in order that justice be done for the benefit of the defendant and his rights to a fair and speedy trial.
Okay, now, Mr. McCarroll, did you hear the motion?
Yes, sir.
Did you have any objections to Mr. Don Dusler withdrawing as your attorney in this case?
I understand.
Okay, so You say you understand. Are you against him withdrawing, or do you consent to him withdrawing?
I mean, yeah, I consent, that's fine.
Okay,
How
okay.
long will it be before
Okay.
I get another
Wait
attorney?
up. Okay, Mr. Dusler, your motion to withdraw has been granted, and your motion is being signed. And Mr. Mr. Dusler, you have been released from representing Mr. McCarroll on this case.
Thank you, Your Honor. And you show that I'm not the attorney appointed on that second case either.
Yes.
Okay, thank you. Sir.
Okay, now, Mr. McCarroll, could you pull up his affidavit of indigency? Just hold on, Mr. McCarroll. We're going to proceed. Yes, Mr. Shearer?
Yes, with Mr. McCarroll, if he waives his right to an attorney, we could dispose of his case today because he did receive 3 years on the 11th of May on another case.
Okay, let me do this here. Now, Mr. McCarroll, as a defendant in a criminal case, you have 3 options. Number 1, you may hire an attorney. Number 2, if you do not have enough money to hire an attorney, you may request an attorney be appointed to represent you. And number 3, you may represent yourself. If you want an attorney to represent you and have enough money to hire an attorney, the case will be reset to give you time to do so. If you want an attorney and do not have the money to hire one, you will need to fill out a financial questionnaire so that the proper person can determine whether or not to appoint an attorney to represent you. Now, Mr. McCarroll, I already have a financial questionnaire that was previously filled out by you. Now, you may not speak to the prosecutor about your case unless you sign a written waiver of your right to be represented by an attorney. Be aware that there are dangers to self-representation. Waiving your right to an attorney and representing yourself may result in a worse outcome for you and your case, including the loss of significant legal rights and opportunities relating to military service, possession of a firearm, housing and public benefits, child custody, immigration status for non-citizens, and employment. If you choose to proceed without an attorney, you may change your mind at any time and may request counsel from the court. If you want to reset this case to hire an attorney, then your case will be reset. Now, if you've already hired an attorney, then that attorney will be contacted regarding a reset date. If you want to apply for a court-appointed counsel, and as stated earlier, we'll have an affidavit of indigency, which is the questionnaire that you've already filled out, then you can do so unless, or if you want to waive your right to an attorney and represent yourself, you can do so as well, but you have to first sign a written waiver of your right to be represented by an attorney. Now, Mr. McCarroll, do you want to hire an attorney? Do you want to see if you qualify for a court-appointed attorney, or do you want to represent yourself?
I'll represent myself, sir.
Okay, now, Mr. McCarroll, I also have, read you this waiver. The waiver states that I have, hold on a minute. And this waiver is contained in State's Exhibit number 1, which is the misdemeanor plea admonishment. I'll just read to you. Okay. And the waiver is in State's Exhibit number 1 on page 2 under the paragraph that's titled waivers. And it states, I have been advised this day by the court of my right to representation by counsel in the case pending against me. I have been advised and understand that if I am determined to be indigent, counsel will be appointed to me free of charge. Understanding my right to have counsel appointed for me free of charge, if I'm found to be indigent, I wish to waive that right and request the court to proceed with my case without an attorney being appointed for me. I specifically waive my right to be represented by an attorney, to consult with an attorney before I give up these enumerated rights. It is my decision to represent myself, and I do so knowing the dangers and disadvantages of self-representation. I further elect not to request appointment of counsel. And Mr. McCarroll, is that your desire?
Yes, sir.
Okay, just hold on a minute.